We are here at the Göttingen Regional Court, reporting on the 28th day of the trial in the Dr. Reiner Fuellmich case. However, the term trial is somewhat misleading. As soon as the crux of the matter comes into view, it's taken behind closed doors. What kind of trial is it where you only learn about the charges during the proceedings? When all key issues are pushed to the closing arguments, such as the demand for questioning key witnesses, and whether the conviction is even legitimate from a corporate law perspective. Sorry, but how is it possible for a media to maintain neutrality in such a situation? Hasn't the court already undermined its own credibility with its secrecy tactics? I'm sharing some impressions from before and after the trial.
Mrs. Lawyer Werner, what do you expect, and what are you bringing to the table today?
I expect a good outcome, solid evidence, submissions, effective counsel, and perhaps more oral proceedings. I hope the whole situation takes a positive turn for my client.
You're new to the defense team. Do you have anything to present today?
I hope to shift the focus somewhat to corporate law and emphasize that the primary objective here was to prevent state access to the company's assets. Simply transferring funds to a bank account doesn't address the issue adequately. We know that the state can claim access to anything we own, so it's crucial to make this process as challenging as possible. We've witnessed with Compact magazine how quickly money can be frozen or withdrawn overnight, and how an entire company can be shut down almost instantly, including the removal of its assets. These are circumstances I never imagined I'd see in this country. It's evident how strongly the state is trying to keep the truth from coming out.
Defense lawyer Paul, you're now part of a team of 4. I haven't had the chance to get you in front of the camera yet. I think our viewers would be interested to know what your role is within the defense team. What have you been focusing on?
Well, the issue is that I joined the case relatively late. The court, and possibly the prosecution as well, have seen problems with the progress of the trial that I don't fully understand. As a result, it was decided to add a local defense attorney to help ensure the smooth conduct of the proceedings. This decision seemed to be subtly interpreted as a tactic by the defense, suggesting that we might be trying to avoid participation or even undermine the process. I don't see it that way at all. I've only recently met my colleagues, so I can't relate to that accusation. My challenge is that I've missed the entire presentation of evidence. I was present for the last witness, Schwab, but he was the only one. In the German legal system, there are no verbatim transcripts of the proceedings, only court notes to which I don't have access. This means that the evidence presentation remains largely inaccessible to me.
Even for you as a public defender?
Our procedural law does not provide for this. Colleague Vermeer had requested that the court records be made available to the defense, but this request was denied based on procedural rules. There is no entitlement to access these records, so I am also completely without access. The only documents I have are a few exhibits and the legal notice issued by the court on May 3rd. I don't have any other information. My colleagues and I have agreed that when the trial concludes and closing arguments are presented, I will need to take a more reserved approach on this matter, simply because I haven't been able to review the proceedings. I'm also interested to see if the fourth colleague will be present today, as I'm not sure about that.
Mr. Simond?
Okay, wonderful. That came up for me spontaneously last time, and I said it would be nice if he could be here again. It can only be helpful, and I'm glad he's back.
Mr. Lawyer Simond, given the extraordinary circumstances and the state's aggressive intrusion into organizational data and assets, isn't this effectively an emergency action by Reiner Fuellmich?
One could see it that way. We observed with Compact how rapidly things can escalate. The fact that during the notary appointment, the tax office indicated that non-profit status would be denied because the organization's statements were critical of the government underscores the importance placed on truth in this political environment. This was an urgent signal that needed immediate action from the managing directors. Since all managing directors had sole authority to act on behalf of the company, there wasn't even a need for a General Assembly, as preventing threats is one of the foremost duties of a managing director.
Mr. and Mrs. Christidis, Dr. Christidis, you have recently submitted a forensic initial analysis stating that this is a case of fraudulent misrepresentation. Could you elaborate on that?
On the one hand, a criminal complaint was filed by Hafen lawyers, Justice Hoffman, Antonia Fischer, and Marcel Templin, in which they alleged that Dr. Reiner Fuellmich was not authorized to carry out financial transactions or engage in other business activities without the approval from the General Assembly. However, this claim is inaccurate. In reality, there is a resolution that is appended to the partnership agreement, which clearly grants each individual the authority to act independently. This resolution explicitly states that each party has the power to represent the firm and to conduct legal and financial transactions without requiring collective approval. Furthermore, this resolution was signed by all Hafen lawyers. In essence, they themselves not only drafted, but also signed the document that gave Dr. Fuellmich the authority to act alone. Despite this, they have now chosen to provide misleading information to the public prosecutor. In doing so, they have omitted the very resolution that contradicts their claims. Although they submitted the partnership agreement and the articles of incorporation to the authorities, they deliberately left out this resolution. The omission of this resolution has led to the initiation of what has been referred to as a deportation process, even though, in reality, it was not a deportation process in the conventional sense. In fact, what took place was a legally questionable procedure orchestrated by public prosecutor Philipp John in cooperation with a liaison officer from the German Federal Criminal Police Office and authorities in Mexico. Together, they executed an unlawful deportation against Dr. Fuellmich. He was flown to Germany on October 12th of last year and arrived there on the 13th, where he was arrested.
When you refer to fraudulent misrepresentation, are you suggesting that the charges against him were manipulated to cause him harm?
Yes, an indictment was constructed in such a way that the Hafen lawyers claimed they were under the influence of Dr. Reiner Fuellmich. They alleged that he had a case involving the political party basis and suggested that he might be inciting violence either directly or indirectly.
Reiner Fuellmich.
Reiner Fuellmich. They claimed he had radicalized the entire party, the basis, as well as the whole Querdenker scene and so on. They also expressed great concern about being defamed. Under this premise, I suspect that this illegal deportation procedure was instigated by Germany and funded by German taxpayers, which I find truly incredible.
Professor Dr. Aris Christidis, what are your hopes for today's hearing?
First off, I'm just hoping for a proper hearing today. What's really on my mind is whether the lay judges, Horn and Voss, will actually say something. None of the other assessors have spoken yet. They don't have to, of course. But this whole indictment seems like a setup to me. The least they could do is listen, or even read through the materials. We've seen similar cases in Hessen, where judges like Goethig, Links, and Wendel quickly climbed the ranks after pushing through dodgy charges. What I don't get is the role of the lay judges. They can't be promoted, but they can be paid. I'd really like to know what they're doing and what they're letting happen in their name. Sadly, we'll probably never hear from them directly. So I'm curious if we'll get any clarity on that today.
Das hätte ich gern gewusst, aber wahrscheinlich kriegen wir sie nie zu hören oder zu sprechen. Aber da bin ich auch gespannt, ob da vielleicht irgendetwas zu erkennen ist.
Thank you. Do you have the impression that this is a politically motivated trial?
I can't really say much on that. From what I've heard from my co-defender, there was apparently a shift in the atmosphere around early May. I wasn't there to witness it myself, but it seems like the court's attitude may have changed. Personally, I haven't seen any clear signs that this is a political trial. I know my colleagues might have some information that I haven't come across yet. Mr. Mesri even mentioned last time that he's received something that could possibly point in that direction. I can't say much about that yet, as I'm not familiar with it.
Hat ja beim letzten Mal auch schon angekündigt, da etwas zugespielt bekommen zu haben, was möglicherweise Hinweise darauf gibt. Da kann ich allerdings noch nicht viel zu sagen, weil ich das noch nicht kenne.
Und die Tatsache, dass die Öffentlichkeit nicht die Möglichkeit
And the fact that the public doesn't really have the chance to see the evidence, Doesn't that suggest it might be a political
Also
trial?
ob das ein Indiz für einen politischen Prozess
I
ist,
can't really
kann ich
say
jetzt so
whether
nicht
that's an
einschätzen.
indication of a political
So
trial.
noch nicht erlebt.
It's certainly very unusual.
Hinterfrage für mich auch tatsächlich den Sinn und Zweck dieser Regel.
I haven't encountered anything like this before.
Alles klar, allerdings sehe ich die Beschleunigung. der
I am
gar nicht
genuinely
leicht.
questioning the purpose of this rule.
Also wir haben die letzten
Legally, it's allowed, yes, but I don't see the acceleration it's supposed to achieve.
ganz großen Teil durch
The
Unterbrechung.
recent trial days have been marked by constant
Wir
interruptions.
empfinden jedenfalls nichts mit
To me, that doesn't speed up the process. It just disrupts each day in court. I've never experienced anything quite like it.
Indeed, a construct was created to remove him and silence him. From the way everything has unfolded, that's how I see it, if I can put it that way. As we look at today's court proceedings and the entire case, it feels like we're watching a script that also matches the dossier Christophe Mazery received from intelligence sources.
Where can this dossier be found?
I downloaded it from Biddle TV. I'm not certain, but it might also be available on ICIC Law. The dossier provides detailed plans on how to undermine Reiner Fuellmich, ensuring he does not gain more influence within the party-die basis, especially in the context of a potential candidacy for Chancellor. Additionally, it outlines strategies to push him into legal jeopardy. Everything is thoroughly documented in the dossier.
And who is the author of this dossier?
We don't know. Lawyer Dr. Mazery mentioned that he received it from intelligence services. Unfortunately, I don't have any more information.
I'm shocked. I need a moment to take this in. I'm completely drained.
That's also a statement.
This has really affected me emotionally.
Mrs. Verma, were you surprised that the prosecution gave their closing arguments today, before the evidence was completely presented?
Oh, well. Yes. Today's development was somewhat unexpected. However, the judge Carsten Schindler had been indicating for some time that this might happen. For weeks or even months, the court has maintained that the evidence collection was officially concluded as of May 3rd. Since then, we have filed numerous motions from the defense, but only a few have been granted. We've heard 3 witnesses during this period, with all other motions for evidence being denied. I've scheduled 2 additional witnesses for Friday and another for the following week. So, it was surprising to see the prosecution move to closing statements in the middle of this process. Nevertheless, I have confirmed with the judge, Mr. Schindler, that we will still have the opportunity to present our witnesses. We can submit further examination requests again in writing and additional evidence motions as part of the closing arguments. This procedure was also reaffirmed in our discussions with the judge Schindler, who has consistently emphasized this point.
Wir können auch noch Beweisanträge in den Schlussplädoyers stellen. Das haben wir auch so quasi mit dem Vorsitzenden besprochen, beziehungsweise hat immer wieder darauf hingewiesen.
Can this still be discussed at all?
Naja gut, verhandelt wird ja über.
Well, in any case, our evidence motions aren't being properly considered anymore. For the past 2 months, all evidence motions that have been rejected are being decided in the final judgment. This has been the situation all along, so there isn't really any change. It was somewhat surprising that, after we had submitted and discussed our evidence motions today, the prosecutor, Mr. Philip Yon, suddenly stood up and delivered their closing argument. However, it's worth noting that the closing argument was notably brief and lacking in substance. It was quick and painless, just like one of those minor fines, like a €50 parking ticket or something. I didn't time it, but was it around 10 minutes or so, without further explanation.
Ja, ich weiß, ich habe die Zeit nicht gestoppt, 10 Minuten oder wie lang war das ohne weitere Begründung?
Pretty much like, just need to get out of here as soon as possible.
Exactly. It may be that the prosecutor, Philip Yon, no longer felt comfortable in his own skin, that perhaps he himself no longer fully stands behind the case. During the trial days, he basically didn't ask any questions to the witnesses, and Edgar Siemens' statement was not admitted. He then submitted his motion for evidence related to corporate law.
It is a societal issue, and he is supposed to submit a proposal. He is here as a corporate lawyer.
Mr. Lawyer Simon, you have recently joined the defense team, but have not yet had a chance to speak. What do you intend to do now that the prosecution's closing arguments have already been presented?
Well, the prosecution, Jon and Reher, acted somewhat prematurely. Even in the limited remarks I was allowed to make, I suggested that we should perhaps take a look at the societal issue involved. However, the prosecution actually referred to a regulation in their closing arguments that is no longer in effect. Honestly, how incompetent can they be? We need to pay attention to those who have something to contribute, rather than pushing them aside.
How is it possible that such crucial aspects were not included in the evidence presentation, but instead were relegated to the closing arguments?
It's quite simple. When nothing further is read out, when the public is excluded, and the prosecution might catch a small legal detail that prevents them from making such a gross mistake, one has to wonder whether the judge handled the situation correctly, or perhaps the judge did not inform the prosecution about the legal aspects that emerged from the submissions, which we then read out in the back room.
Will a hearing or trial still take place or start?
Which hearing are you referring to?
A general trial with evidence presentation. So far, we haven't really been able to participate in the evidence presentation.
You're saying exactly the right thing. What kind of trial is this? What we're witnessing here, in my view, is a judicial farce. The public is kept in the dark, and it's entirely unclear what's happening behind the scenes. I no longer find this worthy of a rule of law. Honestly, I hesitate to even use the term rule of law anymore. It's clear that this is unacceptable.
What more can you, as the defense lawyer, present?
Well, we have a hearing of witness scheduled for Friday, and we hope to clarify a few things during that. I'm curious to see if Miss Viviane Fischer will show up. She has been named as a witness. Otherwise, we have the closing arguments left, and during those, we can present our evidentiary questions for the court to address afterward. This approach to the trial turns everything upside down. It's hard to believe this is happening. I'm truly appalled. I have been involved in many military trials, which were already difficult, but this is beyond the pale.
Do the prosecutors, Jon and Recher, have no intention of investigating the harbor lawyers at all?
So far, they haven't even made an attempt. The fact that the money is with the harbor lawyers has been clear for some time. Our client has been in pre-trial detention for 10 months already. They have known about this from the beginning. One of them, I believe, is named Recher.
Criminal complaints have already been filed against the judge and the prosecutors. What is the current status of these complaints?
Fortunately, I'm not closely following this debacle either. But from what I know about the courts and prosecutors in Germany, I doubt anything will come of it. It will probably be dismissed under Section 172.
Every word is forbidden. Every action is dictated. Everything is scripted. It's a farce that's unfolding here. Unbelievable.
What exactly has made you so furious?
Reiner Fuellmich was asked by the judge why he's been restricted in his preparation and why the motions can't be discussed. He said he's been isolated in the prison since June and described the appalling conditions. Judge Schindler then cut him off with a smug grin. He's not allowed to mention that someone was raped or had their skull smashed in the facility, and then they say, "Why? You can talk to your lawyers anytime." What on earth is going on here? He is not allowed to express himself.
The public would like to know about the current conditions of detention. Are they still as alarming?
Yes, Reiner, as I've mentioned before, he is currently isolated from the other inmates. He's forced to take his exercise periods alone and can only communicate with his lawyers or his wife when the other prisoners are in their cells. This isolation is part of the ongoing troubling situation at Rostorf prison, where there have been repeated incidents of violence. Recently there was a case where an inmate, despite having requested a transfer from the facility's administration due to safety concerns, was not moved. This failure to act resulted in him being severely assaulted by 2 other inmates. He suffered a serious skull fracture and significant damage to one of his eyes. This inmate has since been transferred, but we are actively trying to locate him as we wish to provide him with legal representation. We are deeply concerned about whether he has suffered further harm since his transfer. Moreover, just this past weekend or on Friday, there appears to have been another alarming incident of extreme violence involving another inmate. This situation requires urgent investigation, Preliminary indications suggest that the violence might have been perpetrated by the prison security staff, although we are still in the process of confirming this. The statements from the affected individuals suggest that such violence may indeed be occurring. These conditions are beyond anything one could realistically imagine outside of fictional portrayals in movies or Hollywood depictions of prisons. They represent what can only be described as torture conditions. If these incidents have truly occurred as described, they are not only deeply shocking, but also criminally unforgivable. Such acts should be thoroughly investigated and prosecuted under the law. The situation is highly alarming. We are intensely concerned about Reiner's safety and well-being, and we are urgently seeking to have him removed from pre-trial detention. We are extremely worried about his physical safety and his overall well-being in the current environment. While being in isolation might seem to offer him some degree of protection, it will not shield him if the violence is being committed by prison staff. In that case, isolation provides no real safety. And then we have to act urgently here and get the client out of custody as quickly as possible.
It's a catastrophe, absolutely inhumane. I'm still very emotional, still very shaken. If you haven't experienced it yourself, you really can't imagine what goes on in that courtroom. The client, Mr. Fuellmich, is given a gag order. So Mr. Fuellmich is not allowed to speak. His voice is taken away.
Do we want to discuss this publicly?
That was for a completely different purpose.
For what purpose, then?
You will read it tonight. I'll be posting the next update on our website, then go through it, and you'll see what it's all about. We're dealing with fraudsters here, with a clear directive to destroy someone who's politically inconvenient. That's what it's all about.
Didn't you hear everything I said on his behalf? The problem is, and I brought this up today, why isn't the defendant suing Templin for 1.15 million euro? I don't understand that.
That's clearly what happened, and it was addressed today as well.
But waiting 2 years and then ending up in prison? That's not how it works. You act immediately. The real question is, why is this lawsuit supposedly only being filed now? You can do it right away. If money were taken from you by Templin, you'd run straight to get it back. You'd say, look, what you're doing is unjustified, and I want my money back immediately. And then you'd file a lawsuit. He was able to file a lawsuit at the time because the defendant, Fuellmich, had received 180,000 euro from the sale of a house. With 180,000, I can file a lawsuit against Templin with 1.15 million euro. He could then show in the lawsuit that Templin had collected 1.15 million and wasn't entitled to it. That's something he could definitely do without any problem. I asked this question in court today. Mr. Fuellmich didn't address the question at all. Instead, he just talked about how Viviane Fischer also took money, etc. But that's irrelevant, because he's the one on trial, and what Viviane Fischer did or didn't do is completely meaningless.
Doesn't it make you question things when the direct witnesses are not heard?
Viviane Fischer has already been heard.
Yes, but that was back then under different circumstances. Things have changed in the charges now.
What has changed in the charges? The situation remains as Viviane initially stated. It was a liquidity reserve intended to keep the ongoing operations of the Corona Inquiry Committee running smoothly. This was necessary even if, for example, state authorities or banks had cancelled the accounts that were held in trust for the committee by the attorneys.
He transferred the money to the Corona Committee, but Templin is still refusing to release it. So what on earth do they want? This whole situation is blatantly absurd. The real agenda is to keep him in custody to neutralize him as a threat to the state. They're clearly terrified of his unfiltered statements and are gearing up to target more people. If one person is locked up, I hope the next courageous individuals will step forward. It's honestly shocking what's happening here. I've never seen such obvious manipulation before, and I'm actually pleased by this obvious exposure because it allows us to keep reporting on it. And, most importantly, all the deceitful liars are being exposed, which I find to be a positive outcome.
To what extent is the accusation from lawyer Mr. Grosenbach that Fuellmich failed to file a lawsuit against Templin justified?
Yes, it's easy to say that when you're not the one affected. Reiner Fuellmich did file an urgent procedure through his lawyers against Marcel Templin. He even pursued an urgent procedure for the entire amount of €1,150,000, as there was also a loan from the plaintiff community class action involved. The overpaid amount of approximately €590,000 should not have been granted to Marcel Templin, even on behalf of the plaintiff community. A main proceeding would have followed. At that time, Reiner Fuellmich was in the USA, and he didn't proceed because it would have incurred very high costs. He may also have been very disappointed overall. On September 2, 2022, Viviane Fischer essentially ousted him from his own format. There was then a public bashing. On September 21st, I believe, there was a broadcast where the three lawyers, Viviane Fischer, Wolfgang Wodarg, and I think Robert Sewis, came together and discussed on camera for several hours, during the committee's actual session time, on a Friday afternoon, how terrible Reiner Fuellmich was and how reprehensible his actions were. He was not given any opportunity to defend himself or even to make a statement on these accusations in his own format. He then only had the chance to address these accusations in other formats like Rojal Bittel and elsewhere, trying to clarify things for the public and the movement. I think this was a very difficult time for him personally. Of course, one can always say that a successful trial lawyer should be able to assert themselves and always do the right thing. However, life isn't always like that, because we're not machines but human beings, and everyone might go through a kind of crisis. I don't want to sugarcoat it. As mentioned, there was the urgent procedure, and throughout 2023 there were ongoing negotiations between the lawyers and Reiner Fuellmich. There was email communication up until shortly before his arrest. Initially, he exchanged messages almost daily with Martin Schwab, who was a witness last week, and with Antonia Fischer and Justice Hoffmann. They supposedly tried to find an amicable solution. Antonia Fischer admitted during her testimony that they were no longer interested in a solution, but only in sending Reiner Fuellmich to prison. The documents also showed that they worked closely with the prosecution. Their goal was essentially to imprison Reiner Fuellmich, while he genuinely wanted an amicable resolution and believed that an agreement could be reached, including with the €700,000. Unfortunately, that did not happen, and he was essentially deceived. We filed a criminal complaint against Marcel Templin in early December, as we believe that the money from the house sale was acquired unlawfully, and possibly also has criminal relevance. We have demanded that Marcel Templin return the excess amount of €590,000. In our view, he has no legal basis for withholding the loan amount for the plaintiff community. Therefore, efforts are being made to recover the money, and possibly, colleague Mesery has already filed a lawsuit in the meantime. I haven't spoken to him in the last 2 weeks. If he hasn't done it yet, it will happen in the coming days. In our opinion, it is completely incomprehensible how Marcel Templin, who is also a lawyer, can keep the money without any legal basis.
What is his justification for holding on to these funds?
No, he did not provide any justification for it in his latest letter. Whether he had justified it at any earlier point, I don't know. What I do know is that he had a real right over the property due to the assignment deed. He charged very high interest on the loan he held for the class action plaintiff community. He threatened the buyer of the house with foreclosure, which ultimately pressured the buyer into accepting the high interest charges, amounting to several €100,000. The situation is quite complex, but it was not handled properly. As a lawyer, he should have known better. And this was also the notary's expectation, as he clearly stated during his court testimony. The notary assumed that since both parties were lawyers, they would resolve the substantive legal issues between themselves. The notary's role was to assess the real right and the assignment deeds. At one point, there was consideration of placing the funds in a notary escrow account or a sequestration account until the substantive legal claims were resolved, but this did not happen. However, this does not mean that Marcel Templin had the right to simply keep the money. As a lawyer, he should have known what was legally permissible, and it would have been advisable for him to return the funds voluntarily, at the very least now. I cannot understand why this has escalated to a legal dispute and why he would let himself be sued again.
We'd also be interested in your opinion. What do you think about the trial?
It was a positive turn in the argumentation from the lawyer, Mr. Grossenbach, who is also associated with Viviane Fischer. He may not yet fully grasp everything as he should, but it's a start.
What a positive turn of events. Let's share this with the audience.
Well, he has definitely requested that Reiner Fuellmich be released. It seems he has recognized that the money wasn't just misappropriated. However, he still lacks, or at least presents, a different perspective on where the money went and why it was lost. But I expect that a lot more will be revealed on Friday about the whereabouts of the money.
Lawyer Grossenbach, were you surprised that the trial reached closing arguments so quickly?
Yes, it was surprising for me. I didn't expect it to happen so quickly. But, of course, the end was inevitable at some point, and it turned out to be today. I wasn't prepared to give a closing statement, but I went ahead and did it. I was also relieved to still be part of the proceedings, which allowed me to clarify that the donors absolutely do not want the funds to go to a non-existent organization, such as the Pre-Nonprofit Limited Liability Corporation. The donors certainly do not want this, as these individuals are not advocating for the donors' interests or for the educational work. Therefore, I believe it is unacceptable for them to receive the money. That's why I also requested the dismissal of the claim, to ensure that these two managers do not gain control over the donations.
Diesen beiden Geschäftsführern die Hoheit über die Spenden zukommen soll.
Mrs. Nicole Wolf, as a trial observer who has meticulously documented the proceedings from the start, could you share your overall assessment of the case and its current status?
Yes, I prefer not to comment on the current status of the case in order to maintain my neutrality. I will continue to report on the proceedings. To clarify, I haven't been an observer from the very first day. I've been observing since the fourth day and missed a few days in between, so I haven't been a complete observer throughout. However, what I would like to comment on is that since I began observing the trial and realized the kind of mess that has been unfolding between the shareholders at the expense of the donors, a donor initiative was established with the goal of reclaiming the donations and allowing the donors to decide where the funds should ultimately go. Today, I found it somewhat strange that Mr. Grossenbach, in his closing argument, suddenly presented the same line of argument. This is particularly alienating, given that Grossenbach, as we all know, represents Viviane Fischer and is clearly not neutral. The donor initiative aims to ensure that the donors themselves determine the destination of the funds. That's what I wanted to emphasize. As for today's court session, I prefer not to comment further at this time. Those interested can refer to my videos once they are completed and available.
Thanks a lot. What is your opinion on the prosecutor, Philipp Jahn's demand for Dr. Reiner Fuellmich to be sentenced to 3 years and 9 months in prison?
Even if the prosecutor's claims were accurate, the demand is still too high. In fact, the application should have been for an acquittal. What I found somewhat odd was the prosecutor's repeated suggestion that we have a peculiar understanding of how to handle donations. We could have learned something from this. If you look at the donation regulations of the Protestant Church, which is beyond any doubt in terms of its objectivity, it states that up to 25% of administrative costs are deemed reasonable. Furthermore, it's important to note that the money in question wasn't used for the 700,000 euros directly. It's only about the loan and nothing else. If the loans were used to secure the funds, one might consider looking into what happened at Compact. Even office chairs were taken away there. In this context, I thought it was a good idea to keep the money as far away from the state as possible.
Will Dr. Reiner Fuellmich end up a free man or behind bars?
Well, he's a free man. He just doesn't know it yet. And that's the issue. If he knew, he'd also know what to do.